Hello, hello, and good morning, everybody. How is everybody this morning? Good morning, Margine. Yeah, I don't think the motion to dismiss the charges, that's going to be a no-go right there, and as is going to be Pryor's also asking that both Wood and Smith be taken off the case, and I don't think that's going to happen either, but we're going to hear his argument. So yes, Rhonda, this will be streamed right from the courtroom. Good morning, Glamady. May M. Good morning. Bonnie Baker. Good morning. Mills Gremlins. Good morning. Good morning. Okay, let me just get into. I'm running a little late this morning, you guys. I got up late, so. Good morning, Karen, Terry, Chris, Susan, Tanya. Good morning. Good morning. I'm just getting the stream set up here, you guys, on YouTube. So just bear with me for a moment. Ask that you please smash that like button on your way in. It lets people know that we are live, helps get us up there in the algorithm. Thank you, thank you. I can see those who are smashing the like button. 28 likes, 44 people in here. Thank you, everybody. Thank you. Okay, I just need to get this streams set up, you guys. So please bear with me for a moment. I usually have this all set up. But I ran late this morning, so my fault, you guys. Now I can't find some settings that I usually have to. I just want to make sure I can change them after. I just want to make sure that you guys can see the live chat replay after the live ends. Excuse me, you guys. Give me a minute. Sorry about that, you guys. I had to take that or I would have ignored it. I've been waiting for this appointment for a mammogram for months. So I had to get that set up. Okay, there's my sister. Good morning, sis. Okay, so I do think I got everything set up here. Sorry about that interruption there, you guys. They'll be starting in about 5 minutes, so we're still good. Good morning, Rhonda, Laura, Elise, stay-at-home mom detective. Good morning, good morning. Shannon's Copper, Muffin Top. It's Mama D. Good morning. Chartreuse Seeker. Good morning. Terry and KS. Good morning, Jack. My sister. Driving, but she will be on when she gets home. Karen in Texas. Hello. Yes, so we are waiting for this to start. It's going to be the Chad Daybell, the motions hearings. He's got motions to dismiss all his charges. And then he's also going for motions to dismiss both Wood and Smith. Also, you guys, that during the wait that we're waiting for this to start, I keep checking the other page here. The read that I did on Joshua Bohannon, Joshua has been found. He's been missing since, I believe, let me just see, June or July. Yeah, it's back in my book here. I don't know where I put it. I believe he was missing in June or July of 2021. He went missing. He has been found in the area that I described, near the house, this broken down house. So he has been found. They have not released anything else yet. They're just that there had been remains found on, I guess, last Tuesday or Wednesday. And since yesterday, the medical examiner did say that it is his remains that are found. So I was contacted by friends of the family and everything yesterday saying that, yes, it was him. He's been found and it was in the area that I had given them. So good news. Yes, it's sad that he is passed, but I am happy for the family that they can now give him a proper burial. So they're asking for, just to be left alone at this time so they can absorb this and deal with it and whatnot. So we're going to give them that. Okay, so also while we're waiting, Lori Vallow. Let me just check and make sure they're not up and running yet here. Lori Vallow there's 4 new orders in her case. Now, the one that I am drawn to the most is this secret status conference that they had just a couple days ago. Now, as far as I'm concerned, in my opinion, you don't have a status conference on a case unless there's something to move forward on. Generally, with her case being stayed right now and her being in a mental institution, I don't know what the benefit of a status conference would be at this point. I do know that they did have some motions to seal the last information that came out regarding, from the doctors regarding how she's doing and everything. That I understand. That has to happen every 3 months, but a status conference, and there's been 2 other orders that were made that are also sealed. So it has all been sealed so far. So I know here in Canada, a lot of the times if they get an order to transport or anything like that, that is all sealed because they don't want to have the risk of anybody knowing when she's going to be moving from one facility to the other, so they can't help try and hijack the transport vehicle or anything like that. I know when like here in Canada, if you've gone to court and you've been found guilty, they're moving you from the jail to a prison. They don't give anybody the date that they're doing that either, because it cuts down on the chance that somebody's going to do something to try and hijack the transport vehicle. So I don't know how it works in the States. I'm in Canada, so but everything has been sealed. Now, like I said, the information from the doctors at the hospital, I do understand how that is being sealed, but all the other orders and there being a status conference is what's got me kind of going, what's going on there? And then if you guys didn't catch it, John Pryor kind of slipped something out in Chad Daybell's last hearing where he says, I haven't gotten, let me just see where I wrote this here. I haven't gotten any transport information yet. So that kind of, and then when I seen the status conference and it's sealed, that kind of got me wondering, do they know that she's about to be transported back to the jail? So I don't know yet, but it's kind of giving me the feeling that there's maybe some movement there. We're going to have to wait and see. Hello, Vicky. Welcome, everybody. This will be starting shortly. I ask if you haven't smashed the like, please smash the like. Let everybody know that we are live. Also, after you smash the like, come on back into live chat and make sure you have live chat selected at the top and not top chat. That way you don't miss any of the chat. Hello, Terry. Hello, everybody coming in. If I've missed you, I'm sorry. Okay, so let me just check here and see what's going on. They should be starting anytime now. Well, thank you, Charlotte Truth Seeker. She's good morning, Willow. Wishing you a wonderful day. Appreciate you and your content. Well, thank you. I appreciate you too. I appreciate everybody coming in. Please smash that like button. Let everybody know that we are live with the hearing. And we know they always run a minute or two late. They've got about a minute before this is supposed to start. So good morning, everybody. Good morning, Compton. Hello and good morning, Tanya. Muffin Top. Hello, everybody. I hope so too. I hope so too. And thank you, everybody, for keeping things classy in here. Yes, they have. They've dragged us on way too long. Oh, thank you, Jean. I appreciate you. Thank you. Good morning, Lee from Idaho. Good morning. Had time to get your pop and snacks? Good show. If you guys hear me clicking, it's just me refreshing the page so I can get this to you guys as soon as it starts. North Idaho. There she is. Everybody's being have, sis, so take your time, do what you need to do there. Hello, Lori, Shivani, hello, Leslie, hello. Hello, Jean Bannock. Thank you. Thank you, thank you. Hello, Lori from Wyoming. Susan, hello. Like I said, this will be starting any minute, you guys, and I will have it up on the screen for you. Oh, thank you, Susan. Lori from Wyoming. Everybody in the house. Leslie, I have no idea, but I think that we are going to be finding out. Hello, niece from Virginia. Yeah, I may invest in one of these. These are the ones that came with my wireless. It's wireless, so. But I mean, it clicks. It clicks. There's nothing I can do about it. We were just waiting for this to get going. Let me turn my sound off on my phone, you guys, so we're not. Hey, Terry says, I like the clicking sound. Yes, we're all glad she made it home. She had the shopping to do this morning. Oh, Cindy. My husband told me if I ever go missing not to worry. I'm so ordinary. They pay him to bring me back. Oh, God. Hello, Jack. Please smash the like button on your way in. Hello, Nancy from Puerto Rico. Wow. I'm just waiting for this to start, you guys. As soon as it pops up on my screen, I will bring it to you. They should be starting any minute now. Manchester, England. Hello, hello. And we all know they always run late, so. And we have got, believe it or not, you guys, we have had really nice weather the last few days. And I was rudely messaged today from the Weather Network saying that we're in for more snow. Between rain and snow over the next, it's going to start as rain and turn to snow for the next few days. It's like, wow. Hills Watcher, Toronto. I used to love, when I lived in Hamilton, I used to love going to Toronto to go shopping. So you guys are supposed to get freezing rain this morning. Did you guys get the freezing rain, Hills Walker? Whatever you guys get, we get hours later. So it usually comes right down the 401 corridor there. Oh my gosh. Yes, prayers to them. Polar vortex is on its way. Colorado. Hello, Jean. Leslie. I swear I'll eat my left slipper if they find anything that can stick. I don't think any of it's going to be. Funnier things have happened, right? Farah. I was born at Joseph Brant Memorial Hospital and then moved to Hamilton and lived in Hamilton most of my life, but I was born at Joseph Brant Memorial Hospital right there on Lakeshore and Beach Boulevard. So hello from Farah, my old stomping ground. It's nice to see people in from my old stomping ground. Weather's out of control. Yeah, weather's bipolar. Yep, it sure is. Nothing up yet, you guys. I don't know why they are taking their sweet time this morning, but we know that. Let me just go over here and check the docket on Vine, just to make sure. I haven't. Like I said, I got up late this morning. It's going to be while I'm checking this that they start. Just to make sure that they haven't canceled it. Oh no, he's still on the docket for 9:30 their time, which is 11:30 my time. And that was my phone, you guys. Let me just check somewhere else here. Okay, they're live. Go figure. They're just starting.
Mr. Pryor, state's represented by attorney.
Can everybody hear,
attorney
please?
Blake. Rob Wood is also attending for the prosecution, and Rachel Smith also attending on this
Press
remote
1 if
Zoom
you can all
hearing.
hear,
Mr.
please.
Archibald, counsel for a co-defendant case. We are conducting this hearing remotely. It's being live streamed on the court's YouTube channel for public access to the hearing. In addition, it's being recorded on the court's Zoom software as well as the FTR system. And there's a record being made by attendance of a court reporter who's making a transcript of the proceedings this morning. The hearing today is on a defendant's motion to dismiss the indictment due to failure to seat an impartial grand jury. I'll note that pleading was filed under seal in the case appropriately as it pertains to information relating to some argument on individual grand jurors whose identifying information is to be kept confidential under the rule. However, this court will conduct the hearing today with an instruction to counsel, which we will do in a separate breakout room on the record, but outside of the court's view or of the public view, to discuss the parameters of what I think should be argued in public or not throughout this hearing. Procedurally, going through how we got here, I'll note there was a motion to dismiss initially styled as a 12B motion filed on June 21st of 2021. There was an extension requested for that, which the court granted. That deadline was extended to September of last year, 2021. There was a renewed motion filed September 2nd. There were some objections filed by the state on November 8th to the continuance of the motion. There was a second renewed motion to dismiss filed on December 8th. And then the court issued an order on February 4th stating that there would be this hearing held today on March 23rd. Indicated that a memorandum in support needed to be filed no later than March 9th. Mr. Pryor timely filed his memorandum on March 8th as part of the motion. And at this point, the court has not received any written pleading or objection filed by the state. I would note that during a hearing, I did indicate that I intended to take argument on the motion today to keep the matter moving along. The state had requested this hearing to be continued, and in lieu of continuance, I indicated that I'd be willing to allow argument on the motion today and for supplemental submission of briefing and authority to be submitted at a time to be determined at the conclusion of the hearing by the state. So with that in mind and procedural history, we will go forward on the motion today brought by the defendant to dismiss the indictment. At this time then, I do want to conduct a first, what we'll call a breakout room, which is essentially a sidebar in the virtual world here on Zoom. And in that breakout room, I'm going to discuss with counsel the scope of what I think ought to be referenced in the public purview versus what needs to be kept confidential under the rule for grand juror secrecy. So at this time, Madam Clerk, if you would please arrange for the breakout room, we'll go in there and discuss that issue, then we'll come back and commence with argument on the motion.
And you should all be able to join that room.
Okay, so they are in a breakout room, you guys. He is going to, I'm going to explain what I think is going on right here, right now. I'm still hearing stuff going on in the courtroom. I'm going to leave it open so when they come back, you guys will be able to see it right away. So what I am getting from this is when they, the reason that he is asking for dismissal is because he says there was a failure to seat an impartial grand jury. So in other words, what he is saying is somebody that was sealed, it was not supposed to be talked about, whatever. So what Pryor is trying to say is that somebody that was seated in that grand jury or people that were seated in that grand jury have released information that was discussed in the grand jury, which is sealed. They're not supposed to discuss any of that. So that's what I am understanding right now. Yeah, Shivani, he's going to give instructions on, because this is being broadcast and it's in regards to things that have been sealed, like the grand jury hearing that they got the indictment on, it has been sealed. It's been sealed since it first came out. And what Pryor is saying is that somebody who was involved in that grand jury proceeding has spoke about what happened in the grand jury seating. So his legal term is failure to seat an impartial grand jury. So he has to give instructions on what can be talked about in front of all of us, because there's a lot of it that's been sealed. Well, the whole thing for the grand jury has been sealed. So there's going to have to be ways around them speaking about what actually happened in that grand jury sitting. So I don't think it'll be too long that they're in the breakout room. He's just going to go over instructions with them about what they can and cannot mention, because some stuff is under seal. Yeah, the jurors are given specific specific instructions about this. So from what, like I said, for those who are just joining, please smash that like button on your way in. Let people know that we are live. So from what I can understand from this so far is that somebody that sat on that grand jury spoke about the case when they weren't supposed to, or there could be a couple of people who spoke about it when they weren't supposed to, because the motion is for failure to seat an impartial grand jury. So yeah, I wouldn't be surprised if Mean is the one that leaked something. Now, I don't know. We're going to remove that though, but I don't know if that is true, so I'm not going to allow it to stay in chat, but I did acknowledge it. So this should not take very long. 90 people in here, 150 viewers. Please pop out of live chat, smash that like button, and then pop back in. Make sure you have live chat selected at the top of your chat when you come back in. It's free to do, and it shows that you appreciate me bringing stuff like this to you and taking the time to do so. I would appreciate it if you'd smash that like, and it also brings us up in the algorithm so everybody knows that we're live so they can come in and see this too. Like I said, somebody is still on camera, but with their camera turned off because I can hear stuff in the background. I bet. Hi, Kimmy. Hello, Trisha. Shannon's Copper, Chris H. Hello, everybody coming in. Lovely lady. Shelly Dawson. Hello, 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 everybody. I'm sorry if I've missed you. There's BNN. Hello, hello. There's my sister. MMM. Hello, hello. I'm trying to get to everybody that I can hear. Vicky H. Hello. Bubs B. Hello, my dear. Love you, girl. Please. Hello. Okay. Janice. Hello. Dawn. Hello. Cop Toot. Terry. Tony. Shannon's Copper. I don't know if I've said hello to all you guys already, but I'm saying it again as I can. Hello, Dog Mom. Callie. Be kind. Laurel's Heart. Cot. Hello, hello, everybody. Leslie. I hear a lot of movement in the court, you guys. I know this isn't going to take very long. Hello, Kimmy. That's funny, Chris. Huh? You probably wouldn't get the truth out of him anyway, but yes, me too. And for those of you who don't know yet, the motion to sever was denied at this point. Please smash that like button on your way in. I've got my earbuds in that my sister sent me. She spoils me to death. Thank you, sis. And that was loud. So whoever is still in this breakout session without their camera on is, I don't know what they're doing, but they're pretty loud. But at least we know we still got connection. And as soon as they come back, we will see them pop up on screen here. Waving back at you, Dawn. Yes, thank you in advance for clicking on that like. It lets everybody know that we are live. So please hit that like button on your way in. When you come back into live chat, please make sure you got live chat selected at the top of your chat box instead of top chat so you don't miss anything in the chat. Thank you. I'm seeing you guys hitting the like button. Thank you. Thank you. Thank you. I appreciate it, and it's free to do. And it does help show your appreciation for me bringing all this to you. So I really appreciate it. Thank you. Sure truth. Suggestion. Uh-oh. Suggestion. Okay. Hello, and Sherry's opinion. Please smash the like button on your way in. No, we have now found out, for those of you just joining us, I'll bring you up to speed. The reason for John Pryor filing the motion to dismiss the charges is for failure to seat an impartial grand jury. Apparently, there's been a couple of people that were on the grand jury that decided they were going to speak about the case, and the case had been sealed. They weren't allowed to speak about anything. So that's where we're at right now. They've gone into a breakout session so the judge can instruct them on what they can bring to us, because it is sealed, what they can talk about over the Zoom and what they can't. Thank you, BNN. Thank you. Hey, I appreciate every little bit, you guys. I very much appreciate that, BNN. Thank you so much. Shelley says, I wonder how Chad is like in jail. He's really not going to like the state pen. Yeah. The ghost of Mark Mean strikes again. Yes. So we don't know who yet, but we are going to find out when they return. I don't expect them to be in the breakout session long. The judge is just instructing them on what they can speak about and what they can't over the Zoom, because we are all allowed to watch it. And it's still sealed. So thank you so much for that, BNN. I appreciate it. Thank you, you guys, for smashing the like. I appreciate that too. Thank you. Thank you. Whoa, somebody just coughed. That was loud. Hello, Yellowstone Mandy. Sharon Carter. Hello, hello, everybody coming in. Oh no, sister. Trisha says, do they have to disclose the person or persons? No. They will probably name them by juror number 1, juror number 2, juror number 3, or whatever. Dawn says, freezing rain here in Kitchener. Yeah, we're supposed to be getting it bad here, but because we're farther north, it's going to turn to snow, and we're going to have snow for the next few days. So, hello, stars 0716. Hello, hello. Yes, thank you, Chartreuse Seeker. I appreciate that. Absolutely, they will. They could have some charges coming their way. Please smash that like on your way in. Okay, so this won't be a very long breakout session. The judge is just going to be going over what they can discuss in front of us all, because it is sealed. But obviously somebody that was part of that grand jury indictment, somebody spoke and they were not allowed to. So that's why the reason that Chad was arrested was on the grand jury indictment. Now, once the grand jury finished doing what they had to do, they were instructed that they are not to speak about anything that was discussed within the grand jury, including the witnesses were also told they could not speak about anything that happened when the grand jury was sitting. somebody did, possibly more than one. Here they are coming back. There's the judge. So everybody should be coming back in the room now. Let's find out what is going on here. You're very welcome, Monica. Once it starts, I will be muting myself again. Susan says, sorry about the cereal. Okay. Oh, there's Mr. Wonderful. Lindsay Blake. Oh, God.
All right, appears we're ready to go back on the record here. Is the court reporter ready?
Yes, Judge.
Okay, thank you. All right, Mr. Pryor, as I previously mentioned, then you have filed a motion that was briefed and extensively briefed, and the court appreciates that. That was done on March 8th that you submitted that. So if you'd like to offer argument in support of your motion at this time, you may.
And Judge, I think I had indicated at the last hearing on the 17th that my argument was going to be very brief. I provided a memorandum with the court, a briefing of approximately 55 pages on this issue of the motion to dismiss regarding the grand jury impaneling. There were two accompanying briefs that relate to that motion to dismiss that I'd like the court to also consider as they relate to the grand jury proceedings. But Judge, in general, the motion to dismiss is based on the under Rule 6.6 of the Idaho Criminal Rules as it relates to impaneling a fair and impartial grand jury. I have I think in significant detail set forth my reasons for that. I have no intention, obviously, of disclosing the specifics of what I find objectionable. That's laid out in my brief. I'd ask the court to take that into consideration. But Judge, in terms of themes, there's been pervasive media coverage. That plays into the fairness and impartiality of the grand jury proceedings. The prosecuting attorney in this case chose to utilize the grand jury proceeding. I did not choose to do that. They chose to do that. They could have just as easily impaneled a preliminary hearing and chose to go that route. So the decision to use a grand jury was solely on the state. They have an obligation and a duty to impanel a fair and impartial grand jury. It's my position that that was not done. It's my position that the grand jury was, at least in some ways, impartial, or was not partial, was not impartial and was not unbiased. I've laid that out in my brief. The other issue, Judge, is this, is that the potential sentence in this case is death. The severity of this case, and this court addressed that in a prior decision that you set forth, and I believe that was in your memorandum regarding the venue. And you cited that death is different. And the magnitude of the charge, Judge, is what's important here. And when you're considering the validity or the impartiality of a grand jury proceeding, Judge, you have to take into consideration the consequences as a result of that. So there needs to be a higher scrutiny and a higher review of the standards that are set forth. And given that, Judge, I implore the court to look at what I have laid out in my brief and strongly consider that, at least from my perspective, this was not an impartial presentation before this grand jury. I'm asking the court to take as part of this the complete record of the grand jury proceedings. I'm asking the court to incorporate my brief and memorandum filed on the 8th and the two accompanying briefs as they only relate to the grand jury proceedings, Judge. But I think that if you take the opportunity to review my extensive briefing, I would ask the court to dismiss this indictment on that basis. And thank you, Your Honor. I will now defer to Ms. Blake.
All right, thank you, Mr. Pryor. Ms. Blake, what's the state's response on the motion?
I need to unmute first. Thank you, Your Honor. First of all, the state would indicate, as the court had mentioned at the outset of these proceedings, the state has not had an opportunity to get our brief submitted to the court. At the time that this hearing was set, I believe Mr. Pryor was given approximately 30 days, give or take, to submit a brief. We do recognize that Mr. Pryor absolutely timely filed that brief. He actually filed it a day in advance of the due date. Unfortunately, though, we hadn't looked at the timing of that very closely, and it left the state with only 2 weeks and 1 day from the time we got it to this hearing today. So in order for the state to have actually put a brief together and given Mr. Pryor ample opportunity to review that, that was why the state had originally asked for a continuance. As the court indicated, you had authorized that the parties could seek to supplement any argument with briefing. We would indicate to the court we've been working diligently on a brief, and we would intend to supplement the argument today with that brief. I'm not sure if the court wants to set a timeline on that, when that would be due.
I would like to set a timeline. If you've had a couple of weeks now to work on it, could that be submitted within 2 weeks?
Absolutely, Your Honor. And our hope is that we will actually have it submitted by the beginning of next week, but we will continue to work diligently on getting that put together.
Okay, just to be clear then, let's indicate that your brief will be due no later than Wednesday, April 6th at 5:00 p.m.
And Your Honor, the state does recognize that this is defense's motion. I do not know if Mr. Pryor then wants an opportunity to provide any reply, or if he wants to look at it at that time. If he does, I don't know if we also want to set a deadline for any reply brief, whether that be from that April 6th date or just from the filing date that the state actually submits our supplemental briefing.
All right, Mr. Pryor, my inclination on that would be if you want to submit a rebuttal brief to their response, could you have that due a week later on April 13th?
Judge, would it be possible to give me an additional 7 days to 20th? I anticipate a lengthy response from the state, and I want to make sure. I'm sorry about it.
Okay, we can do that. So April 20th for any rebuttal or responsive brief filed by the defense, 5:00 p.m. will be your deadline for that, Mr. Pryor. Okay, Ms. Blake, then if you want to continue with the substance of your argument.
Thank you, Your Honor. In looking specifically at the grand jury proceedings, there are several rules and statutes in Idaho which are directly applicable and govern those procedures, requirements, duties, and remedies in relation to grand juries. Those are Idaho Criminal Rule 6 through 6.8 and Idaho Code Title 10, Chapters 10 through 16. So in large part, those are what the statutes and rules that the state is going to focus on today. Specifically turning to Idaho Criminal Rule 6.6, that specifically provides the grounds on which a motion to dismiss the indictment may be granted, and it lays out very specific grounds. Again, to not belabor the point, I think only a few of those are what was focused on by the defendant. And actually really the second one, that a valid challenge to an individual juror who served on the grand jury that found the indictment, except that finding of the valid challenge to one or more members of the grand jury is not grounds for dismissal of the indictment if there are 12 or more qualified jurors concurring in the finding of the indictment. Then when we turn to the Idaho Code, looking at the first section, 19-1001, it lays out that the people or person held to answer a charge for a public offense may challenge the panel of a grand jury or an individual juror. Idaho Code 19-1002 outlines the very specific grounds for challenge to a panel. And then when we turn to Idaho Code 19-1003, that's where we get the outline for the grounds that are allowed to challenge an individual juror that served on a grand jury. Again, there are several challenges laid out, And I think the focus of the defense has been on subsection 6 and 7 regarding 6, that he has formed or expressed an unqualified opinion or belief that the defendant is guilty or not guilty of the offense charged, but a hypothetical opinion founded on hearsay or information supposed to be true, accompanied with malice, unaccompanied with malice or ill will, shall not disqualify a grand juror or be cause of challenge. And then 7, that a state of mind exists on his part in reference to the case or to either party, which satisfies the court that he cannot act impartially and without prejudice to the substantial rights of the party challenging. Idaho Code 19-1601 also lays out the grounds for setting aside an indictment and includes very specific reasons for which a challenge or an indictment could be set aside. And again, not belaboring those, there are 4 different challenges laid out. And looking at number 4, when the defendant has not been held to answer before the finding of the indictment on any ground which would have been ground for challenge, either to the panel or to any individual grand juror. So what we can see is between the criminal rules and the statutes, there is some overlap when we're looking at challenges to an indictment. And one of the common themes that comes up is a challenge to the individual grand juror or the panel of the grand jury. And that's really been the focus at this point in time on the defense's request to dismiss the indictment. Looking at State v. Edmondson, 113 Idaho 230, specifically provides the grand jury is an accusing body and not a trial court. Its functions are investigative and charging. Goes on to say the purpose of a grand jury proceeding is to determine whether sufficient probable cause exists to bind the defendant over for trial. The determination of guilt or innocence is saved for a later day, as long as the grand jury has received legally sufficient evidence, which in and of itself supports a finding of probable cause. In addition, in Edmondson, the court provided, we note that dismissal is a drastic remedy and should be exercised only in extreme and outrageous situations, and therefore the defendant has a heavy burden. So in these situations with a motion to dismiss or set aside an indictment, the burden is on the defendant, and the courts have found that it absolutely is a heavy burden and that an actual dismissal of an indictment is an extreme remedy. And one of the things that is touched on briefly or is brought up in the by the defendant is an allegation of prosecutorial misconduct. While the state takes the position that there absolutely was no prosecutorial misconduct, and that'll be outlined more clearly in our brief, but if legally sufficient evidence was presented, the indictment must be dismissed if prosecutorial misconduct in submitting illegal evidence was so egregious as to have a prejudicial effect on the proceeding. And that comes from State v. Forbes, and that's an unpublished opinion, 2020 IDA APP Lexus 352 and 2020 WL 5361067, and that is citing to State v. Martinez 125 Idaho 445.
And on that initial first site, what was the name of the party there, or the defendant in that first part of the site?
It is State v. Forbes, FORBES.
Okay, thank you.
And that case specifically cites to Martinez. It also cites to State v. Brandstetter. In State v. Brandstetter, the citation is 127 Idaho 885. And that citation deals with the court accepting that in making a determination, every legitimate inference that may be drawn from the evidence must be drawn in favor of the indictment. Oftentimes what we see with case law is the evidence or any inference is oftentimes drawn in favor of the defendant. However, when dealing with an indictment, Forbes references it, and Brandstetter also sets out that legitimate inference should be drawn in favor of the indictment. The state recognizes that those specific cases we're dealing with whether or not appropriate evidence was admitted or whether any inadmissible evidence was presented to the grand jury. And what we see repeatedly with courts' analysis regarding that specific issue is so long, even if there is inadmissible evidence submitted, so long as there's enough evidence striking the inadmissible evidence, the indictment will stand. And that case talks specifically about the prosecutorial misconduct as well, that even if it's alleged, it has to be egregious. And not only does it have to be egregious, but the defendant needs to establish that based on that misconduct, he suffered some form of prejudice. And again, that burden remains on the defendant to establish that, not the state to establish it didn't happen. But again, the state's position is there was no prosecutorial misconduct. Then looking at a case from the Ninth Circuit, Silverthorne v. United States, that's 400 F2D 627. It also outlines that the grand jury deliberates and indicts as an accusing body on the standard of reasonable probability that a crime has been committed by some person. It is not a trial body. The quantum of evidence necessary to indict is not as great as that necessary to convict. If a grand jury is prejudiced by outside sources, when in fact there is insufficient evidence to indict, the greatest safeguard to the liberty of the accused is the petit jury and the rules governing its determination of a defendant's guilt or innocence. And if impartiality among the petit jurors is wanting, the cure is reversal by the appellate courts. And I cite to that case because throughout the defendant's brief, initially the Idaho Code and criminal rules that were cited to by the state are cited to by the defendant. However, as the argument continues forward, most of the case law cited deals specifically with impartiality or actual or impartial or implied bias on the part of jurors that were sitting on a petit or a trial jury rather than a grand jury. And I'm unaware of any case law or other statute or rule that would make the same analysis applicable to the grand jury. And what we see in Silverthorne is the distinction between a petit and a grand jury, and that oftentimes the petit jury actually hearing the case is the safeguard and may even be the remedy, even if there is found to be any defect with regard to an indictment or how the indictment came about. Idaho Criminal Rule 6C provides in part that the district judge is the one that is in charge of impaneling a grand jury, and that district judge also has the opportunity to inquire of the prospective grand jurors and to determine whether or not they are qualified to serve. It goes on to lay out that specifically there are two things that the court looks to determine if they're unqualified to sit as a grand jury. And one of those is Idaho Code 19-1003, which again outlines the specific standard applied when looking at whether or not a grand juror was improper to be seated. And again, indicating that is a different standard than what is applied to a grand juror that may not be seated, or that a challenge may be made, or what challenges may be made if they are sat on a trial jury or a petit jury. And those are Idaho Code 19-2020. They do allow for different challenges jurors, again, focusing back on the heightened burden that a jury trial is actually tasked with. And Idaho Criminal Rule 6.1b is which that's the rule that provides in part that the prosecuting attorney has the power and duty to also investigate and inquire whether or not there are grounds for disqualification of any grand juror and advise the presiding juror of the possible disqualification of a juror. So the voir dire process through grand jury proceedings is very different than through the trial proceedings. There actually is no inherent right under the Idaho criminal rules that the prosecuting attorney even has the opportunity to conduct voir dire. In this situation, the prosecuting attorney did have that opportunity, but it is not specifically the prosecuting attorney has the right or the duty at the commencement of the presentation of an investigation. And that's in large part because a grand jury may sit and hear multiple cases, and each case may be different. A grand juror may have a disqualification for one case that may be presented to them or for certain evidence, but be able to sit for other cases and other evidence.
All right, Ms. Blay, and I think that's kind of an important point to consider. So you're indicating that because clearly in a trial with petit jurors, you've got a vetting of those jurors through the voir dire process conducted by both sides. In a grand jury proceeding, obviously the defense is not present, and there still needs to be some sort of gatekeeper function to make sure you have fair and unbiased jurors that sit as grand jurors. And so you're saying that under Idaho Code 19-1003, there's a different standard applied to challenging grand jurors, or we wouldn't call it voir dire because it's not really that, but to essentially vetting out those jurors that may not be qualified?
Yes, Your Honor. When you look at those specific rules, they actually outline different reasons for which a challenge can be made to a juror. So 19-1003 has 7 possible challenges that are outlined, which can be brought to challenge an individual juror. Specifically, there is some reference in the defendant's brief to the grounds for challenge under 19-2020, which actually lay out the challenges for a petit or a trial jury, where the challenges allowed are different. And from what the state can discern from looking through case law, it appears that a large part of that differentiation is that the grand jurors, again, are just an investigative body, and they're only making a probable cause determination. They're not making a finding of guilt beyond a reasonable doubt. They're not stuck with that paramount decision that is made by an actual petit or trial jury. We can find no case law to support that the same standards would be applicable to the seating of a grand jury. And I think the statutes actually tend to clear up that issue because they are separated out and those challenges are different.
Okay, I appreciate the response. And so to summarize, you'd say essentially it's a lower standard for seating a petit juror versus a trial juror?
Yes, when you look at what the challenges are laid out, it does appear to be that there is a lesser standard because there are other remedies available short of just dismissal or setting aside a verdict if that's where it ended up with a petit jury or a trial jury. Whereas with the grand jury, there are some other remedies available. And again, one of the remedies highlighted in several cases is the ultimate remedy to cure a defect if the court, unless the court determines an additional remedy is necessary, would be to actually have all of the evidence heard before a petit jury that is impartial and making that final determination.
Okay, thanks for those responses. You can continue.
Thank you. And again, the state doesn't want to get too much into some of the specifics, recognizing that the grand jury is a sealed proceeding, but I would mention that from the state's review of things, and again, this will be discussed more in depth in our brief, but from a review of the transcript from the grand jury proceedings, the state's view on that is the court did repeatedly ask follow-up questions, at times to group and at times to individuals who raised their hands in response to a question. And oftentimes those questions dealt with the juror's ability to remain open-minded, fair, and impartial. The state did the same, because again, while the state can't find a rule on point absolutely giving the state the opportunity to conduct voir dire, we were allowed to conduct it in regard to seating the grand jury. So it is the state's position that both the district court and the state did conduct proper voir dire and did follow up where necessary to ensure that an impartial and unbiased grand jury was in fact seated. Also, and in State v. Dunlap, the court dealt specifically with voir dire in capital cases, and State v. Dunlap is 155 Idaho 345. And it states, while there is no absolute constitutional right to individual voir dire in capital cases, the method of voir dire must comport with due process requirements. So again, that case is actually dealing with the seating of a petit jury versus a grand jury, but it indicates that there is actually no heightened right in a capital case over another case, but that it simply should comport with the due process requirements as any other criminal case should. I think there is some argument, and again, the state will be brief on this because I think it goes into some of the grand jury proceedings, but there is an argument raised regarding the potential of jurors having a relationship with a party or a witness. And the case on point is that the state has found would be State v. Buhanda Velazquez, and that is 129 Idaho 726. And in that case, they did specifically analyze relationships between grand jurors and the prosecuting attorney and whether or not there actually existed a relationship. And that case also cites to a couple other cases where the same analysis was conducted to determine whether or not a relationship between a juror and an attorney would be a basis for disqualification. In State v. Cipher, 92 Idaho 159, the court upheld the trial court's denial of a challenge for cause of a prospective juror who was, at the time of trial, employed by the prosecuting attorney's firm as a janitor. The court held that such a prescribed relationship must be shown to exist between the juror and accused or the person allegedly injured by the offense charged. And then also State v. Major 105 Idaho 4, the court cited to Cipher and held that a relationship between a prospective juror who was a county treasurer and the prosecuting attorney was not that of attorney-client and thus did not suffice to disqualify the juror. And then in State v. Buhanda Velazquez, the court determined as well that there was no impropriety in a juror being sat where the defense alleged that that juror had failed to disclose during voir dire a close and or business relationship with two prosecutors, one who presented to the grand jury and one who just worked in the office. They ultimately, the Idaho Supreme Court ultimately determined that the proper standard was applied in denying the motion to dismiss because there was no actual evidence to support a relationship between the defendant, with the defendant or the prosecuting attorney, and that it was not such that would have affected that juror's ability to be seated. Again, there are specifics that the state will simply provide in their brief. There are several arguments made by the defendant with regard to individual jurors, and the state believes that all of those jurors were appropriately seated and that they wouldn't need to have been removed. And again, when we look back at the rule, even if the court did find any merit in any of the defendant's arguments, so long as there remain 12 jurors that return a unanimous indictment, the indictment would stand. And again, I just highlight that throughout the briefing, Idaho Code 19-2020 is referenced when arguing challenges to specific grand jurors. But again, the applicable section is Idaho Code 19-1003. However, I would indicate the state's position is even if Idaho Code 19-2020 were applicable to grand jury proceedings, it is the state's position that the grand jurors are still proper and qualified and grand jurors. And again, that will be briefed, more fully briefed. And sorry, Judge, I'm just going over some stuff that I do not think would be appropriate to put on the public record at this time. One of the other arguments raised is that there is an incomplete record of the grand jury proceedings. Idaho Criminal Rule 6.2a provides all proceedings of the grand jury except deliberations must be recorded either stenographically or electronically. The defendant alleges the recordings were stopped at times. And the state would indicate that we believe the proceedings were properly recorded, that there is no rule or statute, again, that the state can locate, which would indicate that a recording should continue to be played if the prosecutors are conducting any kind of sidebar amongst themselves and or if the parties are entering into a break. The defendant cites to Dustin v. Superior Court, which citation is 99 Cal APP 4th 1311 as a grounds to have an indictment dismissed based on the recording not being complete. The state would specifically distinguish that case from the case in front of this court. In Dustin v. Superior Court, the real concern was the prosecuting attorney had actually requested or instructed, the court reporter to leave during both the prosecutor's opening and closing statements to the grand jury. The court in that case essentially determined it would be difficult to imagine an innocent reason for the court reporter to be instructed to leave during the prosecutor's comments, except for that the prosecutor didn't want those to be reviewed later. And even in that situation, and that case also was a little different in the sense that they were looking specifically to the fact that it was a capital case. And so capital cases should be conducted on the record. California did not have a specific rule with regard to the recording of the grand jury proceedings. Idaho does require those proceedings be recorded. The state also recognizes the law regarding capital cases. And it is the state's position that those were properly recorded. The defendant has had an opportunity to look over those transcripts and has clearly raised some allegations based on his review of that transcript. And then looking at Idaho Code 19-1605, it provides that even if an indictment is set aside under these grounds, specifically referring to the above statutes, so with the challenges to the impanelment or the individual grand jurors or the other grounds which would allow for review of an indictment and for it to be set aside, it is not a bar to a future prosecution. In addition, when we look at Idaho Criminal Rule 48, which deals with dismissals, it indicates that a court may, on notice to all parties, dismiss the criminal action on its own motion or a motion of either party, and it provides the grounds, and that includes for any other reason if the court concludes that dismissal will serve the ends of justice. But an order for dismissal is not a bar to a subsequent prosecution for the same felony offense. It would bar a prosecution for the same offense if it were a misdemeanor, but not if it is a felony. And then in a federal district court, specifically the court for the District of the Virgin Islands, in a recent decision, US v. Benjamin, 2019 US Dist So DIST Lexus 173202 and 2019 WL 4920875 also looked at the remedies and provide consistent with the impracticality of other remedies concept embodied in both structural and harmless error analysis. The Supreme Court has recognized that defects in criminal proceedings, including those implicating constitutional rights, do not necessarily warrant the ultimate remedy of dismissal of an indictment, let alone dismissal with prejudice, where remedies short of dismissal are available. And that case cites to United States v. Morrison and adopts their language. So again, just in conclusion, it is the state's position that there are no grounds that have been established by the defendant which would support the finding that the indictment needs to be set aside. And that even if the court were to find any grounds to set aside the indictment, complete dismissal and or precluding the state from proceeding forward with another indictment would not be supported by the findings of other cases that have reviewed situations of this nature. And then again, that the defendant does in fact have the burden, and that burden should be established under the appropriate standards set forth by the Idaho legislature and in the Idaho criminal rules. And the state has outlined those today. They will be, again, more fully outlined in our brief. And we would reiterate our request to just submit that supplemental briefing. The state has already granted that, but we will get that submitted as soon as we can so that the court has that for review. Lastly, I do want to touch on this actually, reiterating.
I do have a follow-up question on the issue you've argued on the sufficiency of the record. And it's a pretty specific question. There's a part of Mr. Pryor's briefing where, and I'll just reference you to that, and it's on page 10, where he indicates that the defense should be entitled to not just the roll of juror numbers on the voting roll, jurors identified only by number, but that those particular jurors and their votes should be identified by name also. Does the state believe that is part of the record that the defense is entitled to in the jury voting rolls?
Your Honor, I think my recollection is what the rule outlines, and I believe I don't have it right in front of me, but I believe it's outlined in the Idaho criminal rules that provides that a defendant can have an opportunity to review the voting sheets. In addition, there's a rule that outlines that at the conclusion of any grand jury proceedings, prior to an indictment either being found or not found, that the voting list should be placed into a sealed envelope. At the outset, grand jurors are assigned specific numbers, and so the voting sheet, it's my understanding, contains those individual numbers. Those numbers are assigned to a specific grand juror. I do believe the defense, I will say it this way, actually, I'm unaware of anything that would specifically allow or specifically prohibit the defense from obtaining the names associated with those juror numbers. Because the state would have had the benefit of knowing which juror number was assigned to which juror, it would follow practical reasoning to the state that the defense could make that request and would be authorized and allowed to review that information as part of the entirety of the record. So the state does recognize the voting sheet would not have contained that, but I'm unaware of anything that prohibits the defense from asking for that or that would prohibit the court from granting it. And again, because the state has that knowledge, it would seem that the defendant should be allowed to review that information as well.
Okay, well, I appreciate the response on that issue.
And then the last point I just wanted to touch on again was looking at that Idaho Code 1003 with regard to a challenge to an individual juror. I would just reiterate specifically that a hypothetical opinion founded on hearsay or information supposed to be true, unaccompanied with malice or ill will, shall not disqualify a grand juror. I think there were some challenges raised based on pretrial publicity. Mr. Pryor touched on that briefly today, and I know it was covered more in depth in his brief, but I think without more of a showing than simply a statement that there was pretrial publicity, and because a juror had viewed that must affect their ability to sit as an impartial juror, is clearly, I think that situation was somewhat anticipated by the writing of that rule. Not this specific situation, but that a situation would arise in which a juror would have heard some outside information or seen some kind of news coverage, but so long as they can set that aside, and I think that is covered. So I would just reiterate that, because I think that was one of the other main points raised by the defense in their brief. Again, we'll more fully brief this, especially where we can get a little more into the specifics of this without violating any kind of grand jury process. We'll cover that more specifically in our brief.
All right, thank you, Ms. Blake. So does that conclude the state's argument, Ms. Blake?
That does, Your Honor, unless the court has any additional questions.
Okay, thank you. Mr. Pryor, would you like to offer a rebuttal argument?
Very briefly, Judge. I noted, Judge, that at least a significant portion of Ms. Blake's argument centered around the evidence that was presented to the grand jury. If the court looks at my brief, the vast majority of my argument, Judge, is the fairness and impartiality of the grand jury itself. And I'm going to rest on the evidence, and the evidence is the wrong word, Judge. I'm going to rest on the contents of my brief in terms of what I presented to the court and the attached references to the transcript itself. I do want to touch on something, Judge, in terms of the incomplete record. Ms. Blake and Mr. Wood and Ms. Smith do not get to decide what portion of the grand jury proceedings I get and what portion I have to specifically request. That's not the way the rule works, and it's somewhat concerning to me that Ms. Blake would suggest to the court that Mr. Pryor at any time could make a request for additional information. That's not the way it works, Judge. Mr. Daybell is entitled to the complete record of the grand jury proceedings. Now, I brought that issue up, and I've referenced where I feel that there has not been a complete record provided to me. And I brought up a couple of instances where that, I believe, at least strongly believe, that's the case. But again, Judge, I'm entitled to that information, and it's not a matter of me requesting additional information or requesting supplement or just requesting information that this prosecutor has access to. If the suggestion from Ms. Blake is that, Judge, if I want to challenge any specific juror for cause, you'll need to request that information to find out who they are so that you'll have an opportunity to do that. That's not the way it works, Judge. That's absolutely contradictory to what the rule is set out and the way this thing is supposed to work.
Which rule specifically are you referring to, Mr. Pryor?
Well, Judge, Rule 6.6 of the Idaho Criminal Rules allows me to challenge any juror for cause. And I'm allowed to do that. And I assume that it would be presumed, Judge, that in order to challenge a specific jury for cause, I should be able to know who they are. I should be able to know what their name is. I should be able to know some information. Now, I did in detail in this brief point out issues that I have with specific jurors. And again, I'm not going to go into that. But the fact is that in order to adequately do that, I would assume that it'd be presumed that I'm allowed to have that information beforehand, and that it's not something that I have to continue to request. And I draw a parallel between this, Judge. The state is under an obligation to provide me all the discovery, and there'll be some subsequent motions addressing that. But they're under an obligation to provide me the information. I would assume, Judge, they're under the same obligation, at least to make sure that I have a complete record of the grand jury proceedings. And Judge, I don't want to belabor this, but I think I laid it out in my brief, and I'll ask the court to examine that. But the vast majority of the cases that Ms. Blake referenced, Judge, simply addressed sufficiency of evidence. They did not suggest that in no way I could challenge the sufficiency and the qualifications of the grand jury. And Judge, I'm going to rest on my brief. I think it was sufficient for the court to see that, at least from my perspective and Mr. Daybell's perspective, the grand jury that was impaneled was not fair. They were not impartial. And I'd ask the court to strike the grand jury proceedings and dismiss this action, Your Honor.
All right, thanks for go ahead, Ms. Blake.
Sorry, if I can just clarify, because it was a question raised by the court. I did find the rule, it's Idaho Criminal Rule 6.5 that addresses getting access to the voting sheets. And what I want to clarify is the state would have no problem providing the names that would associate with the numbers. I believe we still have a record of that. The court would have a record of that as well. The problem is, and why that is not provided, is the grand jury proceedings are secret, and there are many rules governing those, and the state is not allowed to provide information regarding those. So the only reason that the state had referenced that a request may be made to the court is either way, whether the court provides that information or whether it comes from the state. It's the state's understanding in looking at the rules governing grand jury proceedings that we can't disclose information without order of the court. I understand Mr. Pryor's point, it's well taken, but I just wanted to clarify, this is not a situation where the state is trying to withhold that information by any means, but it would be information that would either need to be provided by the court or that the state would need to be authorized to provide from the state's interpretation of those rules and statutes.
Okay, I appreciate that final clarification. Counsel, I'll consider this matter submitted as to oral argument on that final remaining issue where there's still a follow-up supplemental brief provided for the defense. I am going to order at this hearing that based on Idaho Criminal Rule 6.5 and a request made by the defense that there's an authorization for the voting rolls to be revealed in terms of identifying jurors by name and not only by juror number. So that information will need to be provided, and I'll authorize that. If you would submit an order to that effect, Mr. Pryor, I'll get that signed so that the administrators of the case in Fremont County and the clerks are able to supply that information, which I presume is held there at the courthouse. That'll be the only ruling I'll make on the issue for today. I will indicate that on the supplemental briefing that's being submitted by both sides, given the nature of the secrecy of grand jury proceedings and for the reasons already determined, allowing for the filing of the first brief under seal, I will order that those supplemental briefs also be filed under seal. And if you could each with your brief just submit an appropriate order also indicating that the matter needs to be sealed and citing the information as being secret under the criminal rules as it relates to grand juries, then we will file those under seal, and that will take care of that administrative process as well. So I'll wait to see the remaining briefs and take the matter under advisement. The court will then issue a written decision after it's been fully submitted. Mr. Pryor, anything further on your motion this morning?
Nothing further, Judge. May we have permission to be excused?
Yes, thank you, Mr. Pryor. Ms. Blake, anything further from the state?
Nothing further at this time, Your Honor. Thank you.
All right, counsel, thanks for your preparation this morning and your arguments, and we will be in recess.
Okay, so that is it, you guys. So what I have gotten from this is I was taking notes along the way too, so please bear with me here. So the defense is saying that there were some jurors that were seated in the grand jury hearing, which got the indictment for Chad Daybell's arrest, that he feels were not impartial, that had, there's a few things here, that they had viewed or watched information regarding the case before the hearing. Number two, let me just see here. There's a bunch here. Okay, so that a couple of the attorneys apparently have worked at the court or are family members or in some way connected to either the court, prosecutors, or defense. So they had mentioned one that one juror had some kind of connection to the court. Apparently, he was a janitor at some point in time with the court. Another one was an extended family member of somebody that was involved in the state side, whether that be the judge or prosecutors. And also, they are also saying that there was also somebody that was connected some way to one of the defendant, the defense. No, not the defense. I can't even read my own writing here. Just as some of the jurors were in some way connected to the prosecuting office or the court itself. One was mentioned as an extended family member of a prosecutor, and the other one that they had brought out was apparently a janitor at the court at some point in time in the past. So the defense thinks that they have a valid challenge on some jury members, that they weren't impartial, that they had already formed an opinion on the case, and that they were prejudiced. I can't even read my own notes here. So the judge is also, because some Vera Ray, how do they know if they watched clips if they don't know their names or who they are? Because a couple of the jurors have spoken publicly. And that was part of the very first beginning part of the motion, is that they had spoken out about things that they were not supposed to. They're also saying that they did not get the full transcript of the grand jury hearings, that parts were missing. The prosecution came back and said, well, the parts that were missing is when they either did sidebars, which are not recorded, or during lunch breaks and stuff like that. They're saying that there was nothing, the prosecution is saying that there's nothing where evidence and whatnot when the court was in session. They're saying that all of that is there, but there are parts that are missing because those are sidebars or when the judge has asked for it not to be recorded. And there are instances in any hearing or trial that there are times that things aren't recorded. The defense also brought up proper voir dire. The prosecution is saying that that was done. Proper questions were asked of each person that was going to sit on the jury. But the prosecution also stated that I'm trying to get back through my notes here as to where I put this. That the bar is lower in a grand jury sitting than in a trial. The grand juror is totally different from a normal juror, whereas the reasonable doubt is lower. It's a lower standard for reason. In a normal jury, you have to find guilt beyond a reasonable doubt. The standards in a grand jury hearing is a lot lower to find that he is the one that done this or not. The grand jury also has less, there's a burden of proof that is usually judged by in a normal trial. That bar is lower for the grand jury, and the grand jury always errs on the side of the prosecution. And even if somebody on the grand jury panel or a single juror, it's not enough for a dismissal. The dismissal of an indictment, the bar to dismiss is set very high, and they do not feel that the defense has reached that level for a dismissal. that there are also other remedies that could be applied, which means that they could have an appeal on the grand jury's findings, but there's a lower standard, and it always errs on the side of the grand jury anyway, and of the prosecutors. But yeah, the defense is saying that the grand jury was not recorded in total, and the prosecution came back and said, no, there's sidebars and breaks that are not recorded. The prosecution has always also stated that there was no prejudice by any of the jurors, that they were asked specific questions, and that they reached the bar to be able to be seated on the jury for the grand jury hearing. The prosecution is also saying that they have an obligation for a fair and impartial jury to be selected for the grand jury, and they are saying that they were not biased or impartial. The defense is raising this because the sentence in this case is death, so that they should have a higher standard. But I mean, there's a standard that is set for any grand jury hearings, whether it's a death sentence case or a felony. The rules are the same, but the defense is saying that there should be a higher standard in this case because the sentence that he is facing is death. So most of his brief, John Pryor's brief, is saying that it was not an impartial jury that sat and on the grand jury hearing, and that there was at least one person on panel that was not impartial either. He's also saying that he is entitled to the list. What I said before this even started, they generally refer to the jurors by number, like juror 1, juror 2, juror 3. The defense is wanting the numbers to match with full names of the jurors. The prosecution stated that they're not allowed to release that without a court order. So the court did make an order for authorization of the voter roll by name and number to the defense. So that is one thing that the defense did get today. So they're not going to just have juror number 1, juror number 2. They're going to have their actual names that go with their numbers, so they can investigate those jurors. I think that there's going to be more briefs that are going to be filed once the defense gets the actual names of each juror. They're going to be probably getting a private investigator to investigate each and every one of them to see if they're connected in any way to the courts, to the panel, or to the prosecution. But apparently the judge did authorize that list to be released to the defense. The defense was complaining that they were not given that list, and they were supposed to be given the complete record of the grand jury indictment. Sorry for the cough. What else here? Is there any questions? I was just reading my notes, you guys. Are there any questions in specific that you guys have? No, it's done for the day, Robin. They're done. They did not bring up the motions regarding dismissal to have Woods and Smith removed. Those will not be heard, as the defense has said that they want to know the outcome of this first. They want the charges dismissed. If the charges are not dismissed, then they're going to bring forth their motions to have Woods and Smith removed from the case. I'm great, Fluffy Hedgehog. Thank you. Hi, Missy. It's nap time for the crybabies. Because Wood deals with certain parts of the case, and This one here deals with the more intricate because she's death penalty certified. So are there any questions you guys have? Any questions that I may or may not be able to answer for you guys, but if I know Laura had a bunch of questions. The autopsy results have not been fully disclosed yet. We do know as far as Tammy, that was released. I think it was actually illegally released, but she died of traumatic asphyxiation. That's all we know right now. So that means that she was strangled to death. As far as Tylee, she was dismembered and burned and then buried after her death. We don't know the particulars about whose hand actually murdered her. He said that he will give a written rule. I do not expect that written rule to be coming much before the end of April, because they are going to have briefs that they are each going to file now after this hearing. The prosecution is going to file their brief in response to the motions that the defense has filed, and then the defense will probably file a rebuttal to that. The prosecution has to have theirs in by April. Hang on a sec, just let me check here. I believe April 9th, they have to have their rebuttal, their brief in. Oh, April 6th, the prosecution has to have their brief in, which is their response to Pryor's motion to dismiss the charges. They have to have their brief filed by April 6th. And then the defense has till April 20th to file a rebuttal on the prosecution's brief. So I do not believe that we will get an answer on this much before the end of April. Yes, and we don't have access to that yet. So I do believe, and it did come out in my reads. If you guys want to go to, like, when you get on my main page of my YouTube, click the video tab up top, and you can scroll through all the videos I've ever done. Now, at the beginning of this case, I did, especially once they were found, even before they were found, the reads that I did before had brought out everything that was going to happen. And it did happen, and they're now turning on each other. Also, in the reads back then that came out, I believe that something that Tylee was walked to. I believe that when she entered that shed, that red shed on Chad Daybell's property, I believe that she was still alive. I believe that's where it happened, where she was murdered. It is in that shed, and then she was dismembered, burnt, and then buried in the pet cemetery. JJ was, I believe, suffocated or strangled, and he was buried. There was nothing, no trauma that we know of other than the strangulation and stuff, if that happened. His body was intact and buried amongst white and black plastic bags, buried over by a pond that was, I believe, north of the pet cemetery on Chad Daybell's, and both were buried on Chad Daybell's property. And if you remember, the Chad and Alex's phones both pinged on those days that they believed the bodies were buried. Also, Chad sent a text to Tammy, because Tammy was still alive, saying that he had shot a raccoon and it was buried in his pet cemetery. So I do believe that Tylee was possibly shot. Him saying to Tammy that Tylee was shot in that red shed. I believe he sent that message to Tammy saying that he had shot a raccoon to cover up the gunshot that was heard, if it was heard by anybody. and then she was dismembered, burnt, and then buried. And both Chad and Alex's phones were both pinging there on that day also. So he's putting himself there. So Tammy, now that we know it was traumatic asphyxiation, which generally means she was strangled either by the hands of somebody or by, it could be, and I'm just hypothetically here, it could have been a cord from something. I'm getting a cord of some kind, like from a lamp or something like that, like a power cord. But she could have been strangled or smothered by Chad's own hands. But it was traumatic asphyxiation. Yes, Chad was the only one there when Tammy died, apparently. I mean, it's sickening. It's sickening all around. Thank you guys for smashing that like button. I appreciate it. So is there anything else that you guys want to talk about or ask before we end this live? And before we do, I want to thank you guys all for coming and watching the hearing with us. And especially to my mods, thank you. And my sister, she rushed home to be able to get online. Thank you to the other mods that did end up getting able to pop in. Thank you, thank you. Willow, can't their murders be called premeditated because it took thought? Well, I believe that they've got the death penalty. They're going for the death penalty. So all of that will be included. Premeditated is first degree. I do believe they were charged with first degree murder and they're seeking the death penalty. So that is included with a first degree murder charge. I do believe that he was, because he was back at the apartment the next day. And that's when he was going haywire and whatever. So I do believe he was. I don't know domestic autopsy. We don't have the full autopsy report, so we're not going to know that until it comes out in court. No, I think it was buffering. I don't think he was choking. He was very precise in what he was saying. Yes, thank you. Thank you to my mods. They are awesome. Yes, thank you, thank you. So is there any other, need more light on Chad, like to see face expressions? He was expressionless. I'm watching it on a huge monitor and his face was, his eyes were almost closed the whole time. He barely moved. He did move his head once or twice, but other than that, even the blinking was hard to see, but he did blink every now and then. But other than that, he just did not show any emotion whatsoever. Who are you speaking about, Jack? They all had autopsies. All the bodies had autopsies done. And there was no initial autopsy. Chad didn't want one, but they exhumed her. If you're talking about Tammy, they exhumed Tammy's body and did an autopsy. Because Chad did not want an autopsy. Oh, you're very welcome, Terry. Thank you for being here. Yeah, he has no soul. Take care, BNN. Thanks for being here. Yeah, he gave nothing, nothing, nothing. No, I don't think he does at this point. He may now, yes, because he had been given everything, but at first, nobody had it. Except for the prosecution. But I do believe, yeah, he probably has it by now, or he'd be freaking out about it. Yeah, and she died in her bed. He said she died in her sleep. Thank you, Marie. Right? Unless it was a closed coffin. Some religions don't even allow embalming. Hello, Litlo. Hello. This will be available, you guys, about 20 minutes. Once we finish the live, it does go offline for a bit, so I can get all the information put in and whatnot in the description, and for it to upload fully to YouTube. So it's usually within 20 minutes, it's available again. So you will be able to give it about half an hour once the live is done for it to be available again. We don't know that, Mobeans. We don't know that for sure. We don't. Yeah. Okay, so give it about half an hour once we end the live. Yeah, see, unless it was a close casket, remember he had her verified within 3 days of her death, like he was rushing to get her underground for that life insurance. Yep. And he did not want the autopsy. Okay, Litlow. Like I said, usually within 20 minutes once the live ends, it's available. Okay, so if there's no other questions, you guys, there, hello, Des. Litlow is saying hello. If there's nothing else, thank you guys for your super chats and your super stickers. I appreciate it. And thank you for smashing that like button. Thank you for being here and watching us with me. Thank you to my mods. You guys are awesome. So until the next time, you guys, please take care of yourself. Please stay safe. Love you to the moon and back. See you again next time. Please keep an eye on the community tab, and you will see there. I also put any upcoming videos I post there because a lot of people aren't getting notifications. So keep your eye on my community tab. Everything is posted there of upcoming videos, as well as on my Facebook and my Twitter. Okay, so until the next time, all of the links for my Twitter and Facebook are in the description of the videos, and you can find them there. So until the next time, you guys, please take care of yourselves. Please stay safe. Love you to the moon and back. Bye-bye for now.